We've been talking a lot about the federal, Department of Justice. Mr. Downing, the positions that you represent, is that true throughout all of the Department of Justice? Is it specific to just the criminal division which you represent? Are we to assume that this includes the DEA and the marshals and the FBI, et cetera?
The positions that I've been discussing apply across the board to all criminal investigations. I can't speak for national security investigations.
Okay. Just want to make sure I understand the scope. And what's also important for those listening to this hearing and members is that's just the Department of Justice, and the concern is that other departments have their own standards, their own way of collecting and securing these data. As Ms. Duckworth talked about, one of my concerns is what are the standards? Because if you're going back, not having to use a warrant to gather historical information, there's no bounds on that. If you knew that some political group or organization was meeting at a certain location at a certain time, you could go get all that information and not have to get a warrant, correct, Ms. Giuliani?
That's correct, and I think even more concerning is that there's no notice. So, for example, if you're in a situation where the Department of Justice or another law enforcement agency is collecting information about hundreds of individuals and what cell tower they connected to, it's not the case that after 90 days or the conclusion of the investigation that you'll be provided notification and be able to challenge that conduct in court. And that's different than the approach taken, for example, by the wiretap statute. And so what we've essentially got is a situation where innocent people who have their information collected, as a practical matter, just don't have recourse to challenge this conduct in court.
The ACLU did a very interesting report. I can't remember the date of it, but I was fascinated by it. It's part of what compelled my interest in this topic, where you did a survey across the nation of the various law enforcement. I believe it was municipal, county, and state law enforcement. Can you generalize that? And I would ask unanimous consent to enter into the record. Although I don't have it here, I'll get it in the next 2 days. Without objection, so ordered. But Ms. Giuliani, can you give us the framework of that survey?
Sure. We've done 2 surveys. One was we filed FOIA requests with law enforcement jurisdictions across the country to ask, whether they're using collecting location information, and if so, what standards apply. And what we found was, by and large, most law enforcement agencies were collecting this location information, but that standards differed widely. So in some cases, jurisdictions such as those in Kentucky and Hawaii had voluntarily decided to follow a probable cause standard. In others, we found that jurisdictions were following a lower standard or not requiring a warrant. As part of that report, one of the things that we found was that despite Department of Justice policy that states that a warrant should be required for real-time prospective collection, in both New Jersey and Florida, it appeared that there had been cases where location information had been collected without a warrant. So that was one report we've done. The second examination we've done is we've also conducted FOIA requests on the use of stingrays, these cell site simulators which can collect massive amounts of information. And what we found is, despite the fact that there are no federal laws, no federal guidance, even concerning localities that receive federal funds to purchase stingrays, that also the standard varied widely. In some cases, law enforcement were not getting any court authorization. In other cases, even in cases where they received court authorization, they weren't informing judges, hey, this is what we're using, this is the impact of what it has. So judges were, in some senses, blindly signing orders. And the third thing that we found was that there had been a concerted effort to keep these devices secret from both judges and defense attorneys and the public. And so the Department of Justice signs non-disclosure agreements with states and localities who purchase these devices. And those non-disclosure agreements say that information cannot be released. And there may be cases where, in lieu of releasing information to a judge, the state or locality is suggested to drop the case or offer a plea bargain. And that was particularly concerning to us because, as we see it, the courts represent a way to provide oversight of the use of these devices. And to the extent that there is a concerted effort to keep them secret from even these entities, that is a loss to the American people.
So, going back, Mr. Downing, the Department of Justice has these non-disclosure agreements, cell site simulator non-disclosure agreements with state and local law enforcement. Is that something you can provide to this committee?
Yes, we can provide those. I would note, though, that the approach that we've taken, particularly following the cell site simulator policy, is to make clear that we are not trying to conceal, and nor should that policy be implied, to conceal the fact that a cell site simulator was used, and that, of course, there's always an obligation of candor to the court. At this point, the FBI is actually looking again at those non-disclosure agreements and is in the process of revising them, trying to clarify what the approach is now.
Why the change?
Well, I don't know that I have all the factors, but certainly when the environment has changed, there's certainly a lot more information publicly available about these devices. And when the department did an analysis of looking at this whole situation, we decided to institute the policy in the end, and now we're trying to make sure that all of our practices are consistent with that policy.
Now I recognize the ranking member.
Mr. Giuliani,